Welcome to everyone to my talk this afternoon about the obligations for disclosure of documents in Scottish cases pre-litigation. My name is Lewis Richardson. I'm a senior associate and one of the solicitor advocates at BTO Solicitors. So I hope you find this an interesting talk. And there will be a time for questions at the end, but do feel free to interject if you have some pressing issue that you wish to raise. In this presentation, I want to look at some of the general issues underlying disclosure in pre-litigation cases, the obligations of parties under the compulsory pre-action protocol, and where an application is sought under the Administration of Justice Scotland Act 1972, and lastly finish on some other issues which can arise pre-litigation which are worth bearing in mind. So turning first to some general issues, what is the scope of evidence? What can be recovered pre-litigation? Now, generally speaking, when we consider evidence, we think of documentary evidence, being the most obvious kind, but it can apply to real evidence, so land, other types of property, and that can also be subject to recovery or inspection pre-litigation. But for the purposes of today, the focus will be on documentary evidence rather than these other aspects of recovery. So the next point is to bear in mind that at its heart, recovery of documentation is an adversarial process in Scotland. There's no general obligation on party to disclose documents to one another prior to litigation. However, that is an issue, a matter which is subject to change. And as we see, we'll go on, there has been an emphasis on recently in terms of the compulsory pre-action protocols, as well as the compulsory protocols in other types of action, that are not just personal injury, that parties are expected now more and more to enter into frank discussions prior to a case being raised, and certainly that does include disclosure of relevant documentation. And that's only going to increase. As some of you may be aware, the Scottish Civil Justice Council is currently conducting a rewrite of the whole of the Scottish Courts Civil Procedure Rules. And from their 2017 report, they said that they consider pre-action protocols should be provided for all cases where the court has a reasonable expectation of certain steps in disclosure being made by the parties in advance of litigation in the interest of narrowing the issues in dispute in a cause. And that's from their 2017 report. In their 2022 report, which just recently been issued, they say it's recognised that the early and appropriate disclosure of information is important to narrow the issues in dispute and mitigate the length and complexity of proceedings. So whilst Scotland may have started off in an adversarial position of not disclosing any documents to anyone else, that certainly doesn't look like it's going to be the position going forward, and parties to litigations are going to be expected to release documents which in their possession which support their case. And if you don't disclose those documentation, then you can expect the court to take a fairly strict line with that. That said, there does need to be care taken in disclosing documents, and particularly where those documents may be confidential to a third party in the absence of a court order. So then moving to consider the first substantive heading for today's presentation, disclosure under the compulsory pre-action protocol. Now, the compulsory pre-action protocol in Scotland, currently there's only one compulsory protocol, and that applies to personal injury actions with the following criteria. That is where the total of the liability, total value of the claim does not exceed £25,000, and that's exclusive of interest and expenses. But the position can be that the CPAP can be adhered to voluntarily by parties, and that's often the case. The accident or incident giving rise to the claim must have occurred on or after the 28th of November 2016. The claimant must be represented by a solicitor, The claim is not one of the following types, which is a clinical negligence claim, a professional negligence claim, or a disease claim. And for those interested, disease includes any illness, physical or psychological, and where that disorder, ailment, affliction, complaint, malady, or derangement, other than a physical or psychological injury, solely caused by an accident or other similar single event. So essentially the difference between an injury arising out of one event versus a course of conduct seems to be the defining line there. And it is so if your case does fall within the definition of the compulsory pre-action protocol, then it applies. And thereafter, you have to consider what the aims of the compulsory pre-action protocol are. And the highlighted sections there are the ones which are particularly relevant to today's presentation, and that is the emphasis on early and full disclosure of information about the dispute and the narrowing of issues to be determined through litigation in cases that do not reach settlement under the protocol. And it's important to mind when you're dealing with cases under the CPAP, because where there is non-compliance, the court will look at the overarching aims and see whether they've been achieved or not in considering whether there should be a sanction of any kind of any particular conduct. So these really need to be at the forefront of your mind when carrying out any real procedure under or any action under the CPAP, and considering, what would a court make of this? Have I complied with the aims of CPAP? And could I be criticised for this further on down the line, should it come out? So that's sort of the overarching aims and considerations in respect of CPAP. So now turning to the specific obligations. Now, the specific obligations of disclosure focus mainly on the defender, as I'm sure most of you are probably aware if you dealt with a CPAP claim. But they only really kick in when liability is denied. So if liability is denied, that then triggers an obligation of disclosure. And that means that any documentary evidence which is held by the defender or the insurer in a CPAP claim needs to be disclosed along with any alternative version of events that the defender intends to rely on. That also applies in cases where there is an allegation of contributory negligence, but liability is admitted. The documentation, if there is any, to support that case should be disclosed at the same time that it is made. And helpfully, the compulsory pre-action protocol does have an annex containing a list of documents which are likely to be relevant to different types of claims. But really, that's just a guideline, and what needs to be considered is on a case-by-case basis as to whether any documentation actually falls within what you're obliged to disclose. But it's important to remember that this is not an obligation which is absolute. The obligation is restricted and does not include documents that would not be recoverable in proceedings, in particular. And also it does not apply to documents which the defender would not be at liberty to disclose in the absence of a court order. So to consider those two aspects further, looking at documents which would not be recoverable in proceedings, that normally refers to documents which fall within one of the following categories. Those documents, legal professional privilege, those prepared in contemplation of litigation, documents which give self-incrimination, although there are some exceptions to that in respect of intellectual property cases, and documents which are protected from disclosure through public policy. I think the vast majority of documents which fall within any of these exceptions in personal injury cases certainly will be those that have been prepared in contemplation of litigation. So I'll just focus on that for a moment to refresh everyone's memory about what documents fall within that exception. Essentially means that this document's prepared where in anticipation of litigation and or in response to development of litigation that's already been raised. So for that, that means that reports of accidents or internal investigations into accidents are not generally disclosable and not recoverable through either the compulsory pre-action protocol or via court order. There is one exception to that rule, and that is where there's a report made about the accident who was present at the time to his employer, and that is not confidential and may be subject to recovery. So it does require some judgment as to whether any documentations you have about an accident fall within the category which can be safely excluded or need to be disclosed in terms of the rule. Of course, documents which are subject to these conditions can still be disclosed voluntarily, assuming any other parties which may have a claim for confidentiality agree, but that position needs to be carefully considered and not done rashly. There's no point in giving a party documentation which they would not otherwise be entitled to unless it is to your advantage to do so. The second category of documents is that the defender would not be at liberty to disclose in the absence of a court order. That relates to documents which may be confidential to a third party, and assume that covers things like contracts or other pieces of documentation. So it's worth considering, this document is relevant, but do I actually have the power to or the right to disclose it to another party in the absence of a court order? So that also needs to be quite carefully considered. So that's the defender's obligations in terms of the compulsory pre-action protocol. But the defender is not the only person or the party who has obligations. The claimant also has obligations to disclose documentation. But these only really apply where there has been an admission of liability. The pursuers are obliged to disclose any medical report on which they intend to rely, and that important qualifier there, that they have to intend to rely on it, has to be disclosed within 5 weeks of its receipt. And then similarly, that is an obligation that applies to defenders if they happen to obtain a medical report pre-litigation. The claimant must also provide the defender with a statement of allegation of claim in the same form as exists in a litigated action, and that must include supporting documents such as wage loss documentation or other vouching in order that the defender can properly consider the value of the claim. It's an important part of this is that this isn't just you have to accept what the pursuer gives you and then that's it. The rules do allow the defender, where they consider that there isn't sufficient information, they can ask the pursuer or the claimant to produce it in order to properly consider the claim. However, that is a request that has to be made promptly following receipt of the statement of allegation of claim and the documents. The claimant is then under an obligation to provide that documentation within 14 days of receipt of the request. So there's a number of obligations on both defenders and claimants in terms of the compulsory pre-action protocol. So the next question is then, well, what happens if a party does not comply with the protocol? What are the consequences? And there are potential consequences for failure to apply and the failure to comply with these orders, and the court can consider various matters. So the court has the power to take steps that the sheriff considers necessary to do, or the judge considers necessary to do justice between the parties. And in particular, the court can assist the action to allow a party to comply with the requirements of the compulsory pre-action protocol, award expenses against the party who failed to comply, modify an award of expenses for, and also make an award regarding the interest payable on an award of damages. And where a court is considering whether to do any of those things, they need to consider, and the rules oblige the court to consider, the nature of any breach of the requirements of the protocol and the conduct of the parties during the stages of the protocol. In assessing that conduct of the parties, the sheriff must have regard to the extent to which the conduct is consistent with the aims of the protocol. So again, that's a focus on, well, is there a compliance with the overarching aims of the protocol here, and how serious is the breach in that respect, is to merit what sort of sanction the court can award. And majority of cases which have come before the court about these issues have related to pursuers refusing to provide information or refusing to take offers which they then take post-litigation. And the rules are definitely geared towards a pursuer complying with the compulsory pre-action protocol, but that is that's not the only case where there can be a sanction. And the recent decision from the Sheriff Appeal Court, and that's Mary Young against Aviva Insurance, where a defender was sanctioned for their failure to adhere to the compulsory pre-action protocol, and in particular, it was a failure to properly give reasons for denial of liability. Well, actually, it was in that case, it was essentially a failure to comply with the protocol at all. But essentially, it boils down to a failure to properly give reasons for their denial of liability. And in that case, the pursuer had to abandon against the first defender, Aviva, on the basis that a second defender had to be brought into the process, as the first defender blamed them entirely for the accident. But the second defender then settled the claim directly with the pursuer, but that was only done at a very late stage in the action. So despite the pursuer having abandoned against the first defender, which almost certainly in a standard case come with an award of expenses against the pursuer, the Sheriff Appeal Court only allowed the first defender their expenses from the date on which the pursuer should have abandoned the case against them due to their failure to comply with the compulsory pre-action protocol. So if you have a full defence to an action, then it's important to be able to state that to the pursuer so they can consider their position. And if you suddenly come along and produce a defence later on in the case that leads to an abandonment, then don't be surprised if you're not able to recover your expenses. However, with the advent of qualified one-way cost shifting, you're not going to probably get your expenses most of the time in any event. And certainly this particular case was raised just prior to qualified one-way cost shifting coming into force. So it'd be interesting to see what the decision might have been had QWOCs been in force at the time. So that brings me to the conclusion in respect of obligations under the CPAP. Again, there's both parties are obliged to produce documentation at various stages if there is a failure to comply with the objectives of CPAP, or produce these documentation that is within your possession, and then that has a negative impact on the litigation. Parties can expect there to be the court to sanction that behaviour in order for the compulsory pre-action protocol really to have any effect. So in terms of the pre-action protocols, there's clearly an intent by the Scottish Civil Justice Council to bring in more compulsory pre-action protocols, and it looks likely that the next one to come in will relate to disease claims, and in those cases we can expect there to be similar obligations of disclosure, with the likely addition of the claimant requiring to disclose their national insurance schedule of employers on intimation of the claim. So that really concludes what I have to say about the compulsory pre-action protocol, and I'll move on to talk about applications under the Administration of Justice Scotland Act. So first, considering the common law position, the common law Scottish courts would not generally order disclosure of documents before a litigation had been raised, and even in a litigation you often didn't get an order for disclosure of or commission and diligence of documents until after the recorded close and the pleadings had been finalised. There had been exceptional cases where the parties had been able to petition the nobile officium of the inner house to obtain documents or obtain a commission for witness evidence. And whilst that remains a technical possibility, it's, given the advent of the 1972 Act, very unlikely that anyone will see a petition on that basis come before the House. The focus has always been at common law in the Scottish courts, been on recovery of documents in order to strengthen rather than make a case. And if you're looking to obtain documents in order for the purposes to raise proceedings and didn't have a statable case in order to base that on, then that was likely to be considered a fishing diligence, which the court was very likely to refuse. And certainly that is still the case even with the advent of the 1972 Act. So when the 1972 Act was passed, that allowed a much greater powers to the courts to allow recovery of documentation, both pre-litigation and in the course of a litigation. And it applies to recovery of documents as well as inspection of property, recovery of evidence before proceedings. Allows for the so-called dawn raid to preserve evidence with the aim of then raising a principal action. Also allows parties to obtain the identity of witnesses, and that applies to not only before litigation but during a litigation as well. Obviously, there's quite a wide range of different things that the 1972 Act can allow, but for the purposes of today, we're focusing on recovery of documents, pre-litigation, but without the need of a dawn raid. So in terms of procedure, the 1972 Act application can be raised either by petition in the Court of Session or by summary application in the Sheriff Court. The rules of court that have been drawn up for the 1972 Act are quite arduous, requiring averments in respect of why the documents will be lost if recovery is not ordered, and also requiring an affidavit to be lodged in support of the case, and various other matters, which are all really geared towards there being a dawn raid and the need to support that sort of, that quite a significant infringement on the peaceful enjoyment of the haver of their property. But in the burden has been lessened by the Inner House decision Manning against Manning in 2009, which held that, well, those might be the rules, but they only really apply if the circumstances demand it. And there's been no decision along the same lines in respect of the rules in the Court of Session, and no rules rewrite has been undertaken despite the length of time that's passed since that decision in 2009. So for that reason, and probably due to the costs of doing so, most applications of the 1972 Act are made in the Sheriff Court via summary application, and not in the Court of Session. So the most important thing to remember about summary applications is that they are summary and they can be determined at the first calling. So it's important to be prepared to argue your case almost in full if that is required. And I remember appearing in Edinburgh Sheriff before a sheriff who, before calling the summary application case, got out the book on summary applications, ready to cross-examine the pursuer's solicitor about the grounds on which they were seeking recovery of these documents. So all parties need to be prepared to fully argue their case at the first calling of a summary application. And there are some times where parties or pursuers will look to recover documentation and raise a summary application against someone who may have documentation but is not directly involved in the case as such, so isn't the insured but maybe another party. And that's really probably just try to get around insurers or anyone else getting involved in the case. But if that happens and you become aware of the summary application, it is possible to become a party as long as you can establish to the court's satisfaction that you have title and interest to do so. So just because you're not a direct defender of a summary application doesn't mean that it's hopeless and it needs to go through, or the other party or the defender in the summary application needs to take the steps to defend it. So moving on to consider what the requirements are for an order to be granted for the pursuer in a summary application or an application at all under the 1972 Act. They need to establish that the proceedings are likely to be brought, that the documents or property sought are relevant to the claim, and that there's a prima facie case against the defender. So looking at the first requirement there, proceedings likely to be brought, and there's been a recent decision again from the Sheriff Appeal Court on this issue, Hanaway against Discount Trade Windows Limited and others, and that was a case that was successfully defended by my colleague Mark Hastings, who's another solicitor advocate at BTO, and we were able to resist the pursuer's application to recover an insurance policy in that case. And one of the main grounds was the court taking into account that the actual resulting proceedings could not be brought. And that was an objective test. The court just has to look at doesn't just take the pursuer's word that proceedings will be brought. They'll actually look beyond that and actually look at the capacity for the claim to be brought. And the problem in Hanaway for the pursuer was that the principal action was going to be founded on the Third Parties Rights Against Insurers Act 2010 and brought against the employer's liability insurer directly. But because the defender company was still on the company register and no liquidator had been appointed, it wasn't competent to raise an action under the 2010 Act. Or the summary application was refused because it wasn't clear that there was any timescale on which that issue would be purified. So it's not just simply the pursuer stating that they intend to raise proceedings. The court will look objectively and most importantly at, can they raise proceedings in this particular action? Next, considering the next requirement, which is whether documents or property sought are relevant. So the property sought must, there's two requirements, that the property sought must raise relevant questions and also be required in relation to civil proceedings. So in that respect, the property or the documentary evidence should be recovered is a matter of relevancy. So that means that the property must have the potential to have some sort of bearing on the potential action. In terms of civil proceedings, that's a very broad term and probably applies to most proceedings which are likely to come before the courts or other tribunals, but there might be some proceedings such as before ombudsmans where it doesn't apply, and that's more an administrative than a civil matter. So it's still worth considering, is the action which the pursuer is going to seek to raise, is that actually a civil proceeding or not? And the documents which they are seeking must be specified and in the normal detail of a specification of documents, tending to show X, Y, and Z, or whatever is particularly relevant to that particular case. And the last requirement is that the pursuer must establish that there's a prima facie case against the defender, and that is a prima facie case, an intelligible and stateable case, which is made by the applicant. Now that's where things can get quite difficult, because the courts have held that we're in a midpoint between not necessarily requiring a fully pled case, or not requiring a fully pled case, but also requiring that there's enough of a case to make out that on production of these documents, it may allow the pursuer to further specify their case and actually raise proceedings at the end of it. That is, the test is not necessarily that the pleadings in the summary application or under the 1972 Act would survive a debate in a full action, but there must be enough there in order to satisfy the court that this case isn't just a fishing diligence. You're not looking to make a case, but there, again, you're just looking to make your case more specific. And if the pursuer can't satisfy the court that they actually do have a case, then the application should be refused, because then it's simply a fishing diligence in an attempt to make a case that they can't do without the documentation. So that's an important point that can be quite finely balanced in terms of how the court's going to view it. So it's important to be able to or take legal advice about whether any summary application actually meets that test or not. So when it comes to actually recovering the documents in a non-Don Reid scenario, then it would usually proceed by way of commission and diligence. And I would expect that would normally be via the route of an optional procedure in the ordinary court, which is service of a certificate. The haver, the person having the documents, fills it in and returns any documents that that are sought under it. However, there would be within the pursuer's right to seek to fix a commission and cite the haver to attend that along with the documents. And if that ever does happen, then the haver is entitled to legal representation at such a commission. It's also worth remembering that just because there's a court order for recovery of the documents, and as I discussed in respect of the disclosure under the compulsory pre-action protocol, that still doesn't entitle the pursuer to cite of documentation which would be confidential, in the sense that it's either covered by legal professional privilege or that it's a document's been prepared in contemplation of litigation, or one of the other exceptions applies. However, in that event, the document still needs to be produced, but it can be produced within a sealed envelope, sent to the court, and then any motion to open that envelope can be opposed at that time. So in conclusion, in respect of the 1972 Act, there are exacting requirements which have to be met for a pursuer to be granted that order, and that's a recognition really that this is a step outside the norm, and the courts will be looking at that very carefully to decide whether or not an application can be successful. Worth also remembering that even if you're not a party or direct party involved in the summary application on the face of the documentation, it still doesn't mean that you can't necessarily enter the process and become in as either a party minuter or otherwise get involved in the case, as long as there's sufficient title and interest. And if the proceedings are likely to be raised against you, then I think that probably justifies or would give satisfaction that there is sufficient title and interest. A last point about expenses. I wouldn't have thought this is not personal. Some applications are not personal injury claims, therefore the qualified one-way cost shifting shouldn't apply. So an award of expenses, if you're successful in defending a summary application, is a possibility. But the inverse is that obviously if there's an extended amount of procedure, if there's appeals or anything like that, then the expenses can become quite expensive if the summary application ends up being granted. So that brings an end to my discussion about the 1972 Act. And to end today's talk, I'm just going to raise a couple of other issues which are worth considering when it comes to recovery of documentation. And the first is, of course, subject access requests under GDPR. The scope that could form a presentation on its own, but broadly, subject access requests allow people to obtain personal information which an organization holds by you, lets them find out how they're using it, who they're sharing with, and where they got that information from. So they can be a tactic used by pursuers to sort of circumvent either an application of the 1972 Act or other form of obtaining documentation prior to litigation. but the amount of documentation that's subject to a subject access request is restrictive, and there are a number of exemptions which can be applied should a subject access request be made. So they really need to be looked at very carefully rather than just simply complied with. The other issue to be aware of is not just applications under the 1972 Act which can be made in an attempt to cut you or cut an interested party out. There can be circumstances where a pursuer raises an action against the defender and seeks commission and diligence for recovery of documentation in that action, but with a view to serving that specification of documents on you and obtaining with a view to obtaining documentation which supports a case against you. And in that scenario, there is restricted oversight by the court on the terms of the specification, particularly if it's not opposed by the defender in that case. You can find yourself facing a specification of documents which is much wider than would be granted if it was opposed, or likely granted if it was opposed, and certainly probably wider than would be allowed under the 1972 Act. And your remedy for that is really quite restrictive. You almost have to go and force them to take you to a commission and refuse to produce any documentation before you can then address the court about it. And also that's quite an extreme circumstance, but I've been involved in at least one case where that has actually happened, and the client has faced an order for recovery of documents out of an action of which they're no part, and can't actually challenge, or not easily challenge, the order for recovery of that documentation. So that really brings me to the end of my presentation today on pre-litigation recovery of documentation, covering the Compulsory Pre-action Protocol and the 1972 Act. So I hope that you found that interesting, or at least somewhat entertaining for over your lunch break. And thank you all for coming, and I'm happy to take questions if there are any.
Hello, Lewis. It's Mark Morton here.
Oh, hi, Mark. Hi.
I just wanted to pick up on a really important point I thought you made during that seminar, and that was at the point that you're, as a client, faced with a Section 1 application, it's helpful to get advice. And I've got practical experience of that, because generally speaking, my hunch, and you can disagree if you think, is that if someone's actually going to the bother of making a Section 1 application, more often than not, they don't quite have all the evidence that they think they need. So they're up to no good quite often. And if they make an application, as I think you've explained, there are two things that you could basically trip up as a pursuer. One, you don't have a prima facie case. And two, actually, whilst you might have a decent case, you're actually trying to go hunting for evidence to try to get a better case. And we had a practical experience of this recently. There was an interesting fire. The pursuer didn't really know what was going on. Their expert went out, had a look at it, and was sort of struggling. They had a hunch as to what was going on, but was struggling, and accepted in his report that they couldn't really form a view on the probable cause of the fire. And of course, that became our red flag. Well, that means you can't really say you've got a prima facie case. So we had fun and games in the sheriff court, and they bombed it out and they were sent away. But they were quite crafty. They came back and they said, well, they'd spoken to their expert, given them a bit more evidence, and they had a theory. And this theory got them to the point where they had a prima facie case. But what they were desperately looking to do was to try and uncover evidence to make their case a lot better, because they knew their evidence about negligence was rubbish. So what they tried to do was include all sorts of calls for inspection records and maintenance records on the part of our client. And of course, that was nothing to do with the case which they'd pled. So yet again, we managed to put the brakes on it. And lo and behold, 2.5 years later, no court proceedings have gone. Now, if our client had actually just thought, yes, this is all very relevant, we'll hand over all the relevant documentation in relation to this, we'd have probably given them a whole lot of information that might have made their life much easier. So I'm in total agreement with you that actually you should use these processes as a sort of red flag. What's going on here? Is this person really in a position to start litigating, or are they up to no good and to get advice?
No, absolutely. I think that's the key thing about almost all these cases, is that, you know, obtaining proper legal advice is always the best course of action. And as you say, you know, if someone's raising a 1972 Act case or application, the chances are, you know, they don't have the documentation. If you can draft a stateable case and you're happy with your stateable case, then why not just raise it normally and then seek recovery of documentation within that case? It does suggest that there's an additional level of worry about the matter if you're going down the 1972 Act route. So yeah, I would definitely agree that obtaining you know, legal advice on the receipt of one of these, or if you obtain knowledge about one that's going around by a matter in which you're interested, then you know, there are things that can be done about them. And as you say, it can head off litigation which might otherwise arise.
And the other thing I wanted to ask you about, which was a point I confess I hadn't picked up on, and that was this move away from what had always been a sort of traditional approach, that basically we're in an adversarial system, and as a defender in Scotland, you're not required to produce anything really unless the court order you to do so. Are we still at a point, do you think, where that holds true for many actions if we ignore the personal injury protocols?
I think yes. Other than commercial actions, it's still, you know, acceptable to take that approach. I think in commercial cases, there's still a very strong presumption that parties will have fully, you know, ventilated their positions prior to the raising of the action. But I mean, I think, you know, in all these pre-litigation things, no one's going to release or everyone's going to try to avoid documentation that harms their position, I suppose. You know, I suppose the focus is on that, making sure that, you know, if there is documentation you're releasing, then it actually helps you rather than hinders you. But you know, I think with an eye to the future, what's going to happen is that if you that parties are going to be obliged to disclose as much as they can, or much as they should, and if you don't do that, and it turns out that that's then, you know, determinative of the case somehow, then, you know, the court is likely to voice its displeasure at you for that. But then that's not necessarily a reason not to do it per se, but you know, try to avoid that if at all possible.
That's very interesting. Thank you. As I say, I hadn't spotted that move.
Lewis, could I ask a question, please? Can you hear me?
Yeah, I can hear you. Yes. Yeah, go ahead.
I provide expert witness activities, as I call it, in the 4 jurisdictions of these islands. You know, ranging from Cork and the Republic of Ireland to my work in Northern Ireland, Scotland, and England. And I find sometimes I'm mystified when the pursuers, or the equivalent term in another jurisdiction, they simply ask me to list what I think we should be getting from the defender side. It places quite a burden. And I'm usually asked this fairly early in the proceedings. And sometimes it looks quite simple. That what you should be asking for is obviously all the contemporaneous notes and reports, etc., etc. But it puts a shiver down my back each time I'm asked to do it.
Yeah, no, I think, you know, well, I suppose it depends on a case-by-case basis. I mean, a lot of cases, it might be obvious what documentation is needed. Sometimes I suppose it's quite useful to get an expert's input on what documents would be of use to the expert in preparing their report. And I suppose that could, you know, well, I think that's that's maybe a question of which goes to relevancy. If you're going into a summary application and seeking a whole load of documentation that isn't immediately obvious why it's being sought, then a letter from an expert saying I need X, Y, and Z to be able to fully prepare my report would assist a pursuer or a claimant in obtaining that documentation. So I can see a place for asking an expert for that information or for details to what would assist them. I suppose there's a fine line between just listing off a bunch of stuff which might not even exist, but I can definitely see a place for it if that addresses what your question was.
That's fine, thank you.
And I think Giuseppe's asked a question about case law after Brexit and enforceability of orders to discover documents which are placed outside the jurisdiction. That's where it gets quite interesting because because I think the position post-Brexit is somewhat complicated because I don't think the UK is now party to the Lugano Convention, which I think did have provision for these sort of things. There's probably a number of matters at common law or under different treaties which allow for recovery of documentation by the letters of request procedure. I've not come across that myself. I've not had to request access to documentation throughout the EU. I think now post-Brexit, I think it's probably still going to be possible to do it under at common law. It sounds sensible that there would be a process to be able to enforce an order for disclosure of documentation. Where it can be different is if there's a party to the litigation in Scotland which brings in the jurisdiction of the Scottish courts, and there have been a couple of cases where orders under the 1972 Act have been made for inspection or property not within the United Kingdom or not within Scotland, but that's where one of the parties to litigation is in Scotland, so the court can enforce its jurisdiction that way. But it raises all sorts of very difficult issues in terms of international private law as to what the enforceability of these issues are. So that's a good question. I'm not familiar. I'm not come across any case law, but I imagine it must still be possible, if rather complicated, I imagine, to enforce an order from a country other than the UK for inspection of documentation or property. Don't know if anyone has any questions to add, or if we'll let everyone get on with the rest of their day. If not. Great. Well, thanks very much for coming. Glad it was hopefully it was helpful, and yeah, have a good rest of your day. Okay, thank you.
Thank you.
Thank you, Liz.
Thank you.